is not written. That means that it's not also made by the parliament, so it's not a written law, and also it's a case law. That means that equity is empowered, is strengthened by the decision of the court. And also we have it is developed by the Court of Chancery. It is developed by the Court of Chancery. By the Court of Chancery. Then equity is flexible. Equity is flexible. Then equity is a supplement to the rule of common law. It's a supplement to the rule of common law. So these are the 5 points I would like to mention here. So as part of the features or characteristic of equity, it is not written. So it is not written, it's not in any written document. It is developed, it is not written, so it is not made by the parliament. So it's also a type of law, just like common law, being handed over from one generation to another. And also is number 2, is also a case law. It is being empowered by the decision of the judges, that is the court. And also it is developed by the Court of Chancery. The Court of Chancery developed Court of Equity, developed equity. And also it is flexible. It means that it is not as rigid as common law. It allows Court of Chancery or Court of Equity wants to hear people, want to see the differences between the issues before making decision. And also it is a supplement to the rule of common law. So it is a supplement, means that it is there to support, to assist common law, not to cancel common law, but where common law is having some lapses. So equity is there to amend the lapses, okay, to try to adjust and to bring meaning into what the common law is actually talking about, so that it will be acceptable. Let us look at status of general application. The status of general application is a statute that was actually developed by the these are law made by the Parliament of Great Britain. So that's why we call it status of general application. So the status of general application is a statute or law made by the Parliament of Great Britain. And we have the applicable date is 1st day of January 1900. 1st day of January. So what that means is that all status, or especially the one in Nigeria, the one we are making use in Nigeria today, we still have status of general application we are still making use in Nigeria. Those were the one passed by the Parliament of Great Britain on or before 1st day of January 1900. Other ones passed after that were not applied or made applicable into the Nigerian judicial system. But those ones that were passed on or before 1st day of January 1900 were made applicable on or before. So that was the applicable date, 1st day of January 1900. And that's why we have an example of status of general application which we are actually using in Nigeria today, and we discover that they are law made on or before 1st day of January 1900. We have what we call the Will Act 1874. Will Act 1874. That is testamentary document, law regulating testamentary document. We have Sale of Goods Act Sale of Goods Act 1893. And we have Bill of Exchange Act 1882. And we have Partnership Act 1890. So we have Infant Relief Act of 1874. Infant Relief Act 1874. So these are examples of a status of general application. They were passed by the Parliament of Britain, and they were brought into Nigeria to be administered, or to be made use by courts in Nigeria. Also, we have this condition for the application of the status of general application. That means that in Nigeria, before a status from England will become status of general application that we can make use of, number one, it must be a public act in England, public act in England. So, and also it must be in force at the relevant day, that is first day of January. So on or before this day, it must have been in existence. It must also be applicable subject to local circumstances. Applicable. It must be applicable. That means that a court in England must have been applying it to settle issue. And also, it must not be consistent to Nigerian to local legislation. It must not be inconsistent. So that means that it must agree with local legislation. So it must be in agreement with local legislation. So that is the condition for the application of the status of general application. So that means that before this status of general application we are mentioned about, before they were part of laws in Nigeria, they passed through all this. These were the condition they all passed through. So those laws that passed through this very condition were made applicable so to Nigeria, became part of Nigerian law. Let us look at Nigerian legislation. So this also, we are finished with the received English law. This is another important source of Nigerian law. So it is also part of the primary sources. So we have Nigerian legislation. Nigerian legislation means that law passed by our lawmakers. So in Nigeria today, we have the National Assembly and the State House of Assembly. These are the two constituted body that passed law in Nigeria. So the National Assembly passed what is known as Act of National Assembly, while the State House of Assembly passed what is known as law of a state. We have law of Lagos State, law of Ogun State, law of a state. So these are the two same institution at the national level and at the state level that pass law, that make bills to become law. And also, based on what is written here, it says this is the most important source of Nigerian law in recent times. So that means that the law that we have been having in Nigeria today, those laws that we are using are made by our own legislative body. So it is made up of statutes passed by the legislative organs of Nigerian government. Nigerian legislation consists of statutes and subsidiary legislation. So we have statutes. Those are the law passed by the National Assembly or State House of Assembly, and we have, that is what we call statutes. So, and also we have what we call subsidiary legislation. Subsidiary legislation are law passed by any other body apart from the National or State House of Assembly. So we have, statutes. So, and also we have subsidiary legislation. This subsidiary legislation includes law made by the local government and also any other institution empowered to make law. So we have law made by the institution like school, educational institution, where the Senate will sit and pass law. So those laws and the law made by the local government, all these are known as subsidiary legislation. Why they are called subsidiary legislation is because those laws don't pass through normal legislative process. So it is only law from the National Assembly and State House of Assembly that pass through normal legislative process. That is why law from National Assembly or State House of Assembly, those laws are known as statutes, while other ones are known as subsidiary legislation. Let us look at an example of a Nigerian statutes. We have the Act. These are the examples of Nigerian statute. We have the Act of National Assembly. We have the law of a state, State House of Assembly, law of State House of Assembly. We have Act. We have a decree. These are laws made by the federal military government. And we have edict. These are laws made by the state military government. So these are examples of statutes we have in Nigeria, and which we are still making use of them today. So let us look at another important source of Nigerian law, and it is known as a customary law. It is very important. The customary law consists of rule of customs accepted by members of a community, and it is agreed as binding among them. So that is customary law. In Nigeria, we have customary law that governs our activities. We take customary law to be our law. So it is customary law is a law that developed from us and is being handed over from one generation to another. So that is, so common law is also not written. So it is being handed just like customary law. So we are talking about customary law. So let me make that correction. So common law is the one peculiar to the people of England, which we are making use in Nigeria now. So customary law is the one that we have now. So customary law. So what we have now, we have in Nigeria, we have customary law that is so common to each tribes in Nigeria. So each ethnic group is having one customary law or the other. So, and in Nigeria we have two. The customary law is divided into two because of our system of our religion, the type of religion we practice in Nigeria. So customary law is divided into two. We have what we call ethnic customary law, So we have ethnic customary law and we have Muslim law. So ethnic